The Senate will come back to order. Secretary Reed. Oh, let me get a motion from you. Recognize Senator from the 52nd.
Mr. President, I would ask for unanimous consent to remove Senate Bill 162 off the table.
Secretary, read the caption.
Senate Bill 162 by Senator Huffstetler of the 52nd and others. The bill to be entitled an act to amend Article 1 of Chapter 34, Title 43 of the Official Code of Georgia Annotated related to the Georgia Composite Medical Board so as to provide for the board to implement an automated credentializing system for healthcare providers in this state, to provide for requirements, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Rules recommends that this bill do pass by substitute. Respectfully submitted, Senator Brass, the 6th District Chairman. Mr. President.
The Senator has asked for unanimous consent to remove Senate Bill 162 from the table. Any objection? No objection. Recognize the Senator from the 52nd to speak to the bill.
Thank you, Mr. President. I'll be brief, but I want to make sure we have the votes here as well. We've been working on a system for licensing and credentialing that will greatly improve the time and our workforce in Georgia. Currently, it takes many months to get credentialed and licensed in the state for a lot of our physicians and some of our advanced practitioners and others as well. We've been working on a system. We've tried it out on the medical students. They were doing 15 hospitals, 15 sets of paperwork, transcripts, all like that. We now have it working with them already where they are credentialed at all the facilities. With the automated software that is here and is being worked on, we will be able to license anyone with everything normal in about 2 weeks, as opposed to many months it's taking right now. And then we're hoping to follow that up with credentialing that will be, if you're credentialed at one, you'll be credentialed at all of them. Now, any hospital has the right to have additional credentialing if they want it. We work with the Composite Medical Board. The Georgia Hospital Association is supportive of this bill. It's going to mean that particularly people coming from out of state that we've waited 7 months or over a year to be able to hire, and we'll be able to get them here very quickly and get people working in Georgia and streamline our paperwork. If there's no questions, I'll yield the well.
You have no questions, Senator.
Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection? Previous question being ordered. Chair hears none. Previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none. Committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. Report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor vote yay. All opposed nay. Secretary of State, unlock the machines. Secretary, unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 29th for a motion.
For unanimous consent to pull Senate Bill 100 from the table.
Secretary, read the caption.
Senate Bill 100 by Senator Robertson, the 29th, and others, a bill to entitle an act to amend Code Section 31-10-14 of the official code of Georgia annotated related to issuance of a new birth certificate following adoption and legitimation of paternity determination so as to provide for the issuance of a copy of the original birth certificate to certain adult persons who are adopted, to provide for a fee, to provide for the form of such copy, to standardize terminology relating to birth certificates, to provide for a short title, to provide for related matters, to repeal conflicting laws, and for other purposes. That completes the order, Mr. President.
The senator from the 29th has moved that Senate Bill 100 be taken from the table. Is there objection? Without objection. Secretary, finish the caption.
Senate Bill 100 by Senator Robertson, the 29th, and others, a bill to entitle an act to amend Code Section 31-10-14 official code Georgia annotated and for other purposes. Mr. President, the Senate Committee on Children and Families recommends that this bill do pass. Respectfully submitted, Senator Kirkpatrick, Chairman. That completes the order, Mr. President.
Recognize the senator from the 29th.
Thank you, Mr. President. Colleagues, y'all have voted this out twice before. I certainly hope this is the last time you do it. What this legislation does is it treats adopted children with the same respect that we treat biological children. At the age of 18, an adopted child will now be able to go to the health department and get a copy of their original birth certificate. It is nothing more than that. But today, if a child wanted to, at the age of 18, they would have to hire an attorney, they would have to go to Superior Court, and they would have to give a court order to receive that information. It's that simple. I would greatly appreciate your support on this legislation. And with that, if there are no questions, Mr. President, I'll yield the well.
There are no questions, Senator.
Thank you, sir.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to the main question being ordered? Chair hears none. Main question is ordered. Questions on the passage of the bill. All those in favor vote aye. Yay. All those opposed nay. Secretary, unlock the machine. Senator from the 27th, be on standby. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 27th.
Mr. President, I ask that Senate Bill 140 be removed from the table.
Secretary, read the caption.
Senate Bill 140 by Senator Dolezal, the 27th, and others, a bill to entitle an act to amend Chapter 30, Title 43, the official code of Georgia annotated, relating to optometrists as to provide for doctors of optometry to dispense and sell pharmaceutical agents to patients under certain conditions, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. That completes the order, Mr. President.
The senators move that Senate Bill 140 be taken off the table. Is there objection? Without objection. Senator from the 9th, to you. What purpose you waive it? Okay. Secretary, finish the caption. With no objection, Secretary, finish the caption.
Senate Bill 140 by Senator Dolzall, the 27th, and others, a bill to be entitled an act to amend Chapter 30, Title 43, the official code of Georgia annotated related to optometrists and for other purposes. Mr. President, the Senate Committee on Health and Human Services recommends that this bill do pass. Respectfully submitted, Senator Watson, Chairman. That completes the order, Mr. President.
Recognize Senator from 27th.
Mr. President, I know that you knew this already, but I did not know that the human eye, the cornea in particular, has the most nerve endings of any part of the human body. 7,000 nerve endings per square millimeter. It's astounding. So with that, I bring you Senate Bill 140. Because with those nerve endings comes a lot of medical challenges, and the optometrists currently often have a need to prescribe medicine. Sometimes it's for pain. Sometimes it can prevent the use of oral narcotics. And what this bill does simply is allows them to stock and sell the same medicines that they currently have the ability to prescribe. There's a number of guardrails in the bill that ensure that this is well regulated and controlled. They are not allowed to stock any controlled substances, but this will go a long way to helping patients, particularly who are often in an immediate need of relief, get that relief. And with that, Mr. President, I'm happy to answer any questions. If there are none, I will yield the well.
There are none.
Thank you,
Senator. Is there any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea, opposed nay. Secretary, unlock the machine. Senator from the second, for what purpose do you rise?
Mr. President, I ask for unanimous consent to excuse the senator from 26.
All right, without objection, after the vote, he'll be excused. Senator from the 48th, you're on deck. On the motion, or on the vote, on the passage of the bill, the yeas are 54, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 48th.
Thank you, Mr. President. Ask unanimous consent to please laboriously lift Senate Bill 191 from the table.
Secretary, read the caption.
Senate Bill 191 by Senator Still, the 48th, and others, bill to be entitled an act to amend Chapter 8 of Title 34, the official code of Georgia annotated related to employment security so as to revise certain notice provisions related to benefits and appeals, to provide a definition, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. That completes the order, Mr. President.
Is there objection? Without objection, Secretary, finish the caption.
Senate Bill 191 by Senator Still, the 48th, and others, the bill to be entitled an act to amend Chapter 8 of Title 34, the official code of Georgia annotated related to employment security and for other purposes. Mr. President, the Senate Committee on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Walker, Chairman. That completes the order, Mr. President.
Recognize the senator from the 48th. You're going the wrong way.
Thank you, Mr. President. Senate Bill 191, Department Bill, Georgia Department of Labor. It allows applicants who are appealing a result that they receive by mail that they can opt into a portal to be able to respond electronically. Currently, this is a federal program that's administered by the state. It's currently 15 days. We're not reducing that to 15 days. We're simply saying that they can shrink the time down to do it. There are 70 hearing officers in the state. There are currently 8,000 appeals happening right now across Georgia. And in 2024, they handled 70,000 cases. They're currently doing this in about 10 days. We're just trying to get it done a little bit faster. Happy to answer any questions.
We have no questions, Senator. Does any other senator wish to speak for or against the measure? Senator from the 9th. Oh, you want, oh, okay, she's speaking. All right, you speaking, huh?
Thank you, Mr. President. SB 191, I don't think it means any ill intent, and I do think they're trying to expedite issue, but I rise today just to express a bit of concerns, and I've talked to the senator about my concerns, and I understand that there's a desire here to modernize and enhance the efficiency of the process. That said, this bill does have some different questions for me that I have not been able to get answers for. Firstly, it's not clear how the Department of Labor is going to confirm receipt of a notice, regardless of whether sent by mail or email. Sometimes people miss emails. They get sorted into spam, and we all know that the mail system can be erratic. You know, I'm happy for one of the many attorneys here to kind of clarify in this language what I'm talking about, but my understanding is that among some of the other circumstances where you have official notices like court summons, you get a court summons, you get like 30 days for that. The time here, the time limits here are attached based upon when the recipient receives the document. So when it's initiated, instead of when they receive it, that 15-day time clock starts at that point. So from the day of issue, the person has to, so if it was mailed, that 15-day time clock starts. If it was emailed, we don't know whether the recipient got it or not. That 15-day time clock starts from the day it was issued, not the day they received it. And we don't have a way to confirm that they received it. The other part of this bill I have a concern about is the appeal process. The conditions where a decision can be reconsidered are unclear, and it's also not a viable solution to see this kicked to a court process. So if the Department of Labor says, hey, you clicked at day 14, and the person says, hey, I didn't get the notice, I just got it, it fell into my spam. They can appeal with the Department of Labor, but it has to be an extenuating circumstance, meaning like, I don't know, car accident, something terrible has happened to you. But I know people, and sometimes things just fall by the wayside, especially if you're suffering from unemployment. Maybe you just didn't get it for whatever reason. So if the Labor Department, kind of says at the 14-day mark that, yes, your circumstances falls into an appeal to where we'll give you more time, the Department of Labor determines that. But if they say no, your excuse wasn't sufficient enough for us, it wasn't a real emergency, they're going to deny it. And then the claim kind of goes off to a court system. And so now we're creating more of a problem for this unemployed person. Because who determines what is an emergency or why you didn't receive it? You know, it's just kind of unclear to me. So that's the part of the bill I have concerns about, that appeal process. And the conditions where a decision can be reconsidered and unclear. And it's also not a viable solution to see that this process, like I was saying, get kicked to a court at the end of the line, which is going to cost the unemployed person more money, more time. And that's not a practical or mindful cost. That is, I think, something someone unemployed should be fighting for in the court, realistically. And overall, I don't think this bill is very in touch with the concerns of working people going through the unemployment system. It's already difficult, it's already stressful, and it's a high-stakes process. And we don't need to make anything any harder for them. And I don't believe that SB 119 I don't think it's coming from negative intent. I do think they are trying to expedite the process, but I do want to see some accountability that the person filing the application got it, and the Department of Labor knows they got it, and that's when the time clock of the 15 days start. It's just not fair to hold people accountable for completing a process when a time frame when they have relatively low control over that time frame. And I think this bill just needs a little more tweaking and a little more time to consider. I did talk to the Department of Labor, and they maybe possibly can have a time step process via email to where they know the recipient actually got the denial notice and the appeal process starts, but we don't have that right now. Nor are mail notifications, they're not certified mail, so we don't know when the person is getting it in their mailbox when that time clock starts. So that's just a few issues that I have. Again, I don't think it's ill intent, but I do think, I do have some concerns, and there are just some unanswered questions, and I wish we could do it past the 15 days. Apparently there is something lawful where, federal, that they can't extend it past 15 days. I would see it like 30 days. I would like to see 30 days. But those are just some of the questions that I have. And Mr. President, I will yield for questions.
All right, you waive. Senator from the 36th, do you have a question?
A question.
All
Thank
right.
you, Mr. President. Does the senator yield?
Yes, ma'am.
Quickly, because the hour's late, I just want to put a pin in this and support your what you've pointed out. Isn't it true? That unemployment check is a lifeline. That's a system's been designed. You're laid off. You're eligible for unemployment. Let's don't create another barrier to getting that check, and so that the family can hold it together until they get called back to work or get a new job. Isn't it true?
Yes, that is true, and I get that they're trying to expedite the process, but we don't want to hold up their check in an appeal if they don't know, like they didn't get the notice, or fell off in the mail, fell into spam, that notice. I do want to give them sufficient time to appeal.
And isn't it true that this could be addressed if this bill gets to the House? That there's a way to clean this up. It's not a federal requirement that you have this 15-day notice. Isn't that true?
That is true. I mean, I keep hearing from the Labor Department that it's 15 days. They can't extend it to 30. But I would think there is something that can be cleaned up there to extend that window.
Yeah, thank you. This is a very important issue for people when they're laid off. Can be a life and death situation. Isn't it true?
Thank you. Mr. President, I yield the will.
Senator has yielded. Does any other senator wish to speak for or against the measure? Senator from the 48th, would you like to close or you want to waive?
Colleagues, I'll be brief. 8,000 applicants are appealing currently. If we want to speed this up, email's a little bit faster than snail mail. It's a federal program instituted by the state. They're the ones that set the 15 days, not Georgia. Of the approximately 70,000 cases handled last year, nobody's saying they need more time. We're trying to speed it up. So in good faith, we are trying to expedite this, not slow it down. If you want to make it 30 days, you just double the amount of time to get claims processed. Please vote yes. Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Question is on the passage of the bill. All those in favor vote yea. All those opposed, nay. Secretary, unlock the machine. Senator from 39th, you're on deck. On the passage of the bill, the yeas are 38 and the nays are 16. This bill, having received requisite constitutional majority, is therefore passed. Recognize the senator from the 39th for a motion.
Mr. President, I ask for unanimous consent to lift SB 252 off the table.
Secretary, read the caption.
Senate Bill 252 by Senator Halpern of 39th and others, bill to be entitled Act to amend Chapter 37 of Title 36 of the Official Code of Georgia annotated, related to acquisition and disposition of real and personal property generally, so as to provide for conveyance of municipal property interests to independent school systems, to provide for municipal replacement of such conveyed property, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection to the motion? Without objection, finish reading the caption.
Senate Bill 252 by Senator Halpern of 39th and others, bill to be entitled Act to amend Chapter 37, Title 36 of the Official Code of Georgia annotated, related to the acquisition and disposition of real and personal property and for other purposes. Mr. President, the Senate Committee on State and Local Governmental Operations General recommends that this bill do pass. Respectfully submitted, Senator Dixon, Chairman. That completes the order, Mr. President.
Recognize the senator from the 39th to speak to the bill. Everybody, please be mindful of Senator in the well presenting her bill, and every other senator that will come after her. So keep the noise level down, please.
Thank you, Mr. President. I'm going to keep this very quick. This is a bill specifically for Atlanta, the city of Atlanta, to be able to transfer a piece of property to the Atlanta public school system. We have Hope Hill Elementary School, and next to it there are two parcels, one of which had been abandoned for public use, and that gym has already been given to the school. Another parcel, which is a tricycle park, has not been abandoned for public use, and therefore, because of code that has been set in 30 plus years ago, cannot just be swapped. We have to do this through a bill. Atlanta and the school system are both in agreement. This will be an even swap. This tricycle park is a playground for the kids to service the school, and it will be fenced in as a school safety measure. And I ask for your favorable consideration on this bill. And I will yield unless there are any other questions.
You have no questions, Senator.
Thank you.
Does any other senator wish to speak for or against the measure? Hearing none, does any senator object to the previous question being ordered? Chair hears none. The previous question is ordered. Senator from the 6th, do you have something? But you wave? I can't hear you, Senator. Okay, you wave. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 32nd, you're up. On the passes of the bill, the yeas are 56 and the nays are 0. Wow. Wow. Senator, sounds like you might need to be the minority group spokesperson there. So, I'm kidding, Senator from the 22nd. Don't get sensitive in here. So, all right, on the passage of the bill, the yeas are 56, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize Senator from the 32nd.
Thank you, Mr. President. I would ask that Senate Bill 213 be removed from the table.
Secretary, read the caption.
Senate Bill 213 by Senator Kirkpatrick of the 32nd and others, bill to be entitled an act to amend Part 2, Article 15 of Chapter 1 of Title 10 of the Official Code of Georgia Annotated, related to the Fair Business Practices Act of 1975, so as to ban commercial cheating services that target students and examinees seeking a professional license as an unlawful, unfair, and deceptive trade practice, to provide for definitions, to provide for statutory construction, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, Secretary, finish the caption.
Senate Bill 213 by Senator Kirkpatrick of the 32nd and others, bill to be entitled an act to amend Part 2, Article 15, Chapter 1 of Title 10 of the Official Code of Georgia Annotated, related to the Fair Business Practices Act of 1975 and for other purposes. Mr. President, Senate Committee on Regulated Industries and Utilities recommends that this bill do pass. Respectfully submitted, Senator Cowser, Chairman. That completes the order, Mr. President. Mr. President, Senator Kirkpatrick of the 32nd and others offer the following Amendment 1 to amend Senate Bill 213 by striking as an unlawful, unfair, and deceptive trade practice on lines 3 and 4 by inserting before to provide for definitions on line 4 of the following to limit enforcement to public enforcement by the Attorney General by replacing without otherwise limiting the definition of unfair, deceptive acts or practices under this part it on lines 49 and 50 with it by inserting between lines 56 and 57 the following. D. Any violation of subsection B of this code shall constitute an unfair, deceptive act or practice in the conduct of consumer transactions and for other purposes. That completes the order, Mr. President.
Recognize Senator from the 32nd to speak to the measure.
Thank you, Mr. President. Senate Bill 213 is about commercial cheating services. These companies advertise that they will take your test for you, take your online course or licensing exam, do your homework, or write your essay. This is a billion-dollar industry that has increased in recent years, primarily spread by word of mouth and social media. 4 countries have passed laws to prohibit this, with legislation pending in a number of states. This activity threatens academic integrity and public safety. There are numerous examples that I won't go into. The hour is late. This bill makes it unlawful for any person for a commercial purpose to provide a work product in a substantially completed form. The bill is in the unfair trade practices part of our law, with civil penalties outlined in the law to be determined by the Attorney General. I do have the amendment that makes it clear that this is civil rather than a private cause of action. This bill levels the playing field, and I would ask for your support and would be happy to answer any questions.
You have no questions, Senator.
Thank you. I yield.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of Amendment 1 authored by the senator from the 32nd, the author of the bill. Is there objection to Amendment 1? Without objection, Amendment 1 is added. Is there objection to agreeing to the Porter Committee, which is favorable to the passage of the bill? Chair hears none. The Porter Committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill as amended. All those in favor of the bill vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 14th, you're on deck, and it is his first bill ever in the legislative body. On the passage of the bill, the yeas are 53, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed as amended. Recognize the senator from the 14th.
Mr. President, I would move that SB 173 be removed from the table.
Secretary, read the caption.
Senate Bill 173 by Senator McLaurin of the 14th and others, a bill to be entitled an act to amend Article 3, Chapter 11 of Title 9 of the Official Code of Georgia annotated, related to pleadings and motions as to authorize movements to file notices of uncontested motions in superior courts and state courts, to provide for uncontested motions to be deemed granted, to provide for review by chief judge and any judge with 2 uncontested motions deemed granted on his or her docket, to require management reports regarding each such review, to provide for construction, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Is there real objection? All right, we're going to ignore it. Finish reading the caption.
Senate Bill 173 by Senator McLaurin of the 14th and others, a bill to be entitled an act to amend Article 3, Chapter 11, Title 9 of the Official Code of Georgia annotated, related to pleadings and motions as to authorized movements and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland, Chairman. That completes the order, Mr. President.
Recognize the senator from the 14th. Speak to the measure.
Thank you, Mr. President. Colleagues, I am honored to bring you SB 173. We talk a lot about judicial backlogs, about cases that fill the dockets of courts. This is only for civil cases, and essentially what it is, if there's an uncontested motion, meaning a motion in a case that nobody objects to, no party, no valid intervener, that's been sitting around for 3 months, then it gives a party that makes the motion the ability to sort of tap the court on the shoulder and say, hey, this has been sitting for 3 months. It then gives the judge a week to rule on the motion. If the judge doesn't act, it's deemed granted. And it's got the tiniest little tickle of accountability at the end about having the chief judge look at a judge's docket if this happens twice. Lawyers bringing bills to constrain judges even a little bit, usually kind of a scary thing for lawyers to do. The judges have been great to work with in this process. I've gotten great feedback from the Superior and state court judges on this. So we're hoping to get this to the House where if they want to put some more stuff in, they can. But that's basically the bill, and I'm happy to take any questions, Mr. President.
Would anybody like to question the senator's judicial doge project here? It's a wonderful idea, Senator. Recognize the senator from the 37th.
Thank you, Mr. President. Gentleman, yield.
I do.
Could you describe to me this tickle of accountability in a little bit more detail?
That's right. So on the second page of the bill, starting at number 20, if a judge has this happen twice, so a motion's granted automatically twice after that week-long opportunity, then the chief judge of the circuit just looks at the judge's docket management techniques and issues a report. I don't think this is going to candidly change the behavior of the judges we're talking about in some cases, which, again, the vast majority of judges do a very good job of timely ruling on motions, but every attorney has a war story or a horror story about a motion that sits for a year, for 2 years. And so this is just a way to remind the court, speed up the process, to give them an opportunity to rule on something that shouldn't be controversial at all.
Thank you, sir.
Thank you.
You have a few more questions, Senator. Recognize the senator from the 42nd.
That's Senator Yield.
I do to the Judiciary Chairman.
Senator, you just said the vast majority of judges basically aren't a problem, correct?
Oh, and I wouldn't characterize the ones who are not in the vast majority as a problem. What I would say is that there are times when, dockets get overwhelmed, judges need a little bit of help in, paying attention to the thing that needs attention.
Do you further yield?
I do.
So which judges do you think need that extra help? Who are you referring to?
I have really adopted the habit of not saying any names from the well, and I think that's a practice that is good to extend to all members of the general public if you can help it.
Do you further yield?
I do.
So which circuits do you see this problem in?
I would never want to specify which circuits or which counties have particular issues. Look, my practice brings me to a lot of different counties, and in that process, you get to see a lot of different things, Mr. Chairman.
Do you further yield?
I do.
So which counties do you practice in?
I've practiced throughout the state. I've practiced in Metro Atlanta, down I-16, down I-75, up in North Georgia. Probably 159 counties. If I could tell you the ones I haven't practiced in, it'd take me a minute to think about it.
Do you further yield?
Yes, Mr.
Can you
Chairman.
give an example of one county down the I-16 corridor that's getting it right?
Okay, I had this one motion, okay, and I got really mad about it. No. Look, I think that you know very well, as a lawyer legislator, this is a touchy subject to talk about judges and the way that they rule on things. But, oh, you got the microphone back up? But I really have been grateful for the feedback from judges who say, look, we understand that litigants need practical solutions when their cases are dragging. All right.
I've recognized the senator from the 27th.
Thank you, Mr. President.
You're the last senator I'm going to yield to.
I've
Mr.
waited
Senator.
a long time for this moment. This is the senator yields.
I do.
We are carefully crafting an amendment back here and would like to just know what your preference would be. We are working to replace all instances of either a Superior Court judge, a state court judge, a judge. I think that covers it. And we're going back and forth. Should we change it so that it reads, in the event that Elon Musk fails to rule upon a properly served motion, or would you prefer something along the lines of, on line 17 perhaps, should Donald J. Trump continue to fail to rule upon a motion? Which would be a preferable friendly amendment to you of the two options?
Mr. Senator, I am indifferent because you just gave our crack social media team the clip they need to keep tying Musk and Trump together. So thank you again for that, Mr. Senator.
Senator, do you continue to yield?
For one final question, because I need to get out of the well.
It's not a question, Senator. I do just want to say that I appreciate you rolling back the red tape, and I would like to commend you for bringing this bill because it is a good piece of legislation, and I would look forward to voting for it.
Thank you, Mr. Senator. Notwithstanding whether there are further questions, I yield the well.
Oh, wow. We wanted to highlight more of your disapproval of the judicial system in Georgia. Can't wait till you practice. I can't wait for the next judge that you appear before right here. So we've got another amendment here. Is this a serious amendment? All right, well, read the amendment. Now, hopefully you'll withdraw the amendment here.
Mr. President, Senator Hatch of the 50th and others offer the following Amendment 1 to Senate Bill 173 by striking notice of uncontested with pile driver on line 16. Mr. President, that completes the order.
Recognize the senator from the 50th.
Thank you, Mr. President. I rise to bring this amendment. I had a serious bill the other day, and I realized that the senator who sponsors this bill is a huge wrestling fan. And so to honor that, I wanted to honor his bill by adding this amendment that he probably hadn't thought of, and I ask for your favorable consideration. Thank you.
I believe the amendment's out of order, so we're going to just go ahead and put that all aside. I know, it's awful, isn't it? Does any other senator wish to speak for or against the measure? Chair hears none. I'm not recognizing him. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to agree to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 48th, for what purpose do you rise?
Parliamentary inquiry, Mr.
State
President.
inquiry.
Mr. President, if we do look at Senate Bill 173 and we examine by word search lines 2, 4, 5, 6, 11, 14, 15, 16 on page 1, there are 6 instances where the word Doge is spelled in this bill. I was wondering if we could add a second Trump floor leader to this body.
Recognize Senator from the 19th. For what purpose do you rise?
Parliamentary inquiry, Mr.
State
President.
your inquiry.
Does the Senate rules allow for a sua sponte ruling on whether or not an amendment is germane?
I didn't hear you. What did you say, Senator?
I'm sorry, it was French.
You got to speak into the mic, Senator. On the passage of the bill, the yeas are 49 and the nays are 5. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 3rd.
Mr. President, I move Senate Bill 245 be lifted from the table.
Secretary, read the caption.
Senate Bill 245 by Senator Hodges of the third and others, a bill to be entitled an act to amend Code Section 19-7-3, the Fisher Code of Georgia annotated related to actions by grandparents or other family members for visitation rights or intervention, revocation or amendment of visitation rights, appointment of guardian in litem, mitigation, hearing, and notification to family members of child's participation in events derived for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, recognize the senator from the 3rd.
Thank you, Mr. President. Love to follow the senator from the 14th. Colleagues, I give you Senate Bill 245. It is a bill that's good for families and grandparents. It allows grandparents who already have visitation rights granted by a court to go back to court to modify those rights. Current law allows parents, guardians, and legal custodians such rights, but not grandparents. This bill was brought to me by constituents. Couple of retirees on St. Simon's had a grandchild by their son and daughter-in-law. Son died in his early 30s of a massive heart attack. And my constituents thought that it would be in the best interest of their grandchild to petition the court to seek a change in their visitation rights. They found that as grandparents, they had no standing under current law to petition to modify their rights that were established by an earlier order. As a matter of fact, their lawyer gave them a Georgia appellate court case from October of 23, Namdar versus Namdar, which found that grandparents who've previously been granted visitation rights have no right to file an action seeking to modify the existing visitation order. This bill corrects that. I will just say that I acknowledge that Georgia law does and should defer to parents of children about their visitation rights. I really don't believe it right for grandparents to be shut out of the modification process under all circumstances. And I would ask you to remember that a judge would still have to hear facts and make a final determination, and that this bill does not change any of the standards by which such a judge would rule. And I'd yield for questions.
You have no questions, Senator.
Thank you. Appreciate it.
Does any other senator wish to speak for or against the measure? Senator from the 18th, the floor is yours.
Thank you, Mr. President. I'm going to be brief, but this is a very important bill. I'm going to thank the senator from the 3rd for bringing this. You know, grandparents are a part of the fabric of families all across our state. And in many cases, they really provide the family stability in families that face some of the greatest challenges. We've got a law that allows judges to determine whether visitation with grandparents is in the best interest of the child, and that seems completely natural. But the law is not clear, once visitation is granted, whether or not those same grandparents can seek to modify the visitation that they've been granted. As recently as 2022, this chamber, I'm proud to say, voted unanimously to reaffirm that grandparents should be able to seek visitation rights in a bill sponsored by the senator from the 42nd. Since then, I've heard from families in my district, as I suspect that you have too, that couldn't seek to modify their visitation because of this gap in the law that the senator from the 3rd is seeking to modify. I want to also thank the Smiths, who used to live in Macon in my district, sharing their story with the Children and Families Committee, and I offer my condolences to the loss of their son. All they want is to add a couple of days a year to the current visitation that they enjoy with their grandson. But that gap, as I mentioned earlier, means they cannot go back to court and ask for more days. So let's close the gap. Thank you, Senator, for bringing this. I join with the senators from the 3rd, and I hope many others of you for standing up for children and families in this state. Thank you very much. I urge your strong support for this bill. I yield the well.
Thank you, Senator. Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to the report of committee which is favorable to the passage of the bill? Chair hears none. Report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. Senator from the 25th, you're on deck. On the passage of the bill, the yeas are 56 and the nays are 0. This bill, having received a requisite constitutional majority, is therefore passed. Good job, Senator. Good job, Senator. Recognize the senator from the 25th for a motion.
Move. Thank you, Mr. President. I move that the pallbearers assemble over at the table and exhume Senate Bill 260, please.
Secretary, read the caption.
Senate Bill 260 by Senator Williams of the 25th and others, a bill to entitle an act to amend Chapter 7, Title 50 of OCGA related to the Department of Economic Development, says to create the Central State Hospital Redevelopment Authority and for other purposes. That completes the order, Mr. President.
Is there objection? Without objection. Secretary, continue the reading.
Senate Bill 260 by Senator Williams of the 25th and others, a bill to entitle an act to amend Chapter 7, Title 50 of the OCGA related to the Department of Economic Development, says to create the Central State Hospital Redevelopment Authority and for other purposes. Mr. President, the Senate Committee on State and Local Governmental Operations General recommends that this bill do pass by substitute. Respectfully submitted, Senator Dixon, Chairman. Mr. President, the Senate Committee on State and Local Governmental Operations General offers the following substitutes. Senate Bill 260, a bill to entitle an act to amend Chapter 7, Title 50 of the Official Code of Georgia annotated related to the Department of Economic Development, says to create the Central State Hospital Redevelopment Authority and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 25th. Speak to the measure.
Thank you, Mr. President. This is a good bill. I ask for your favorable consideration.
To think he replaced me. Oh, baby. All right. Does any other senator wish to speak for or against that? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. And I think I should explain to you what the bill actually does. It's a Central State Hospital Authority. We're taking it from 9 members down to 4 members. 3 members. Okay. 4 members, 3 voting members. So, yeah. I know y'all didn't understand what the Senator from 25th is, but that's okay. You know, it happens. All those in favor of the bill will vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 8th, you're on deck. On the passage of the bill, the yeas are 52, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize Senator from the 8th for a motion.
Thank you, Mr. President. Elvis and I here, we would like to move that Senate Bill 119 be rocked and rolled off the table.
Secretary, read the caption.
Senate Bill 119 by Senator Goodman of the 8th and others, a bill to be entitled an act to amend Subpart 1 of Part 4 of Article 2, Chapter 2 of Title 8 of the Official Code of Georgia Annotated related to general provisions for manufactured or mobile homes so as to provide for limited exceptions to circumstances under which a manufactured home shall become real property, to provide for preservation of rights and remedies of prior holders in a lien or security interest in certain manufactured homes, to provide for notice and application requirements, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
Senate Bill 119 by Senator Goodman of the 8th and others, bill to be entitled an act to amend Subpart 1 of Part 4 of Article 2, Chapter 2 of Title 8 of the Official Code of Georgia Annotated related to general provisions for manufactured or mobile homes as to provide for limited exceptions and for other purposes. Mr. President, Senate Committee on Banking and Financial Institutions recommends that this bill do pass. Respectfully submitted, Senator Summers, Chairman. That completes the order, Mr. President.
Recognize Senator from the 8th.
Thank you, Mr. President. Going to be quick. Senate Bill 119 is a good affordable housing bill. Currently, if someone buys a mobile home and they want to convert it into real property, they have to get sign off from the lender. The average median income in this state, $74,000. If you have to have it financed as chattel property, the best you can get is 15-year amortizations at 12, 13, 14% interest. If you can convert it into real property, you can get a 30-year mortgage at regular mortgage rates. And so, anyway, good bill. Just you're not going to have to get the sign off from the lender to convert it into real property. If there are no further questions, I will yield the will.
You do have one question, Senator. Recognize Senator from the 53rd.
Thank you, Mr. President. With the senator yield?
I do.
Isn't it true if you mess with one, you mess with the whole trailer park?
That's a fact, Senator.
No more questions, Senator.
Thank you, Mr. President. I yield the will.
Does any other senator wish to speak for or against the measure? Chair hearing none. Is there objection to the previous question being ordered? Chair hearing none. The previous question is ordered. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. Senator from 50th, you're on deck. On the passage of the bill, the yeas are 53 and the nays are 0. This bill having received the requisite constitutional majority is therefore passed. Recognize the senator from the 50th for a motion.
Thank you, Mr. President. I move that we remove Senate Bill 148 from the table.
Secretary, read the caption.
Senate Bill 148 by Senator Hatcher of the 50th and others, a bill to be entitled Act to amend Article 11 of Chapter 2, Title 20 of the OCGA relating to public school property and facilities so as to provide for an outdoor learning spaces pilot program, to provide for a pilot program evaluation and reports, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Not objection. Secretary, finish the caption.
Senate Bill 148 by Senator Hatcher of the 50th and others, a bill to be entitled Act to amend Article 11 of Chapter 2, Title 20 of the OCGA related to public school property and facilities and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Hickman, Chairman. Mr. President, the Senate Committee on Education and Youth offer the following substitute to Senate Bill 148, a bill to be entitled Act to amend Article 11 of Chapter 2 of Title 20 of the OCGA related to public school property and facilities so as to provide for an outdoor learning spaces pilot program and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 50th.
Thank you, Mr. Chairman. I rise to bring you Senate Bill 148. This is a bill that I've worked on the last couple of years with my good friend from the senator from the 5th. We've gotten out of this chamber a couple times. We've fallen short over in the House. Hopefully we'll be able to get it through, but this bill allows the Department of Education to have a pilot program for outdoor classrooms in the state. They're a great learning opportunity for kids, and I just ask for your favorable consideration. I'm happy to answer any questions.
You have no questions.
Thank you, Mr. President. I yield the will.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objections to the previous question being ordered? Chair hears none. Previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 29th, you're on deck. On the passage of the bill, the yeas are 53, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 29th for a motion.
Mr. President, I ask for unanimous consent that SB 98 be taken off the table.
298, I think is what you mean, Senator.
SB 298, yes, sir.
Secretary, read the caption.
Senate Bill 298 by Senator Robertson of the 29th, a bill to be entitled an act to amend Code Section 5-6-34 of the OCGA related to judgments and rulings deemed directly appealable, procedure for review of judgments, orders, and decisions not subject to direct appeal, scope of review, hearings in criminal cases involving a capital offense for which death penalty is sought, and appeals involving non-monetary judgments in child custody cases, as to provide for certain appellate procedures regarding the denial of sovereign and other immunity available to the state or a city or county in the state, to provide for time limitations, to provide for statutory construction, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Objection. Secretary, finish the caption.
Senate Bill 298 by Senator Robertson of the 29th and others, bill to be entitled Act to amend Code Section 5-6-34 of the OCGA related to judgments and rulings deemed directly appealable and for other purposes. Mr. President, Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland, Chairman. Mr. President, Senate Committee on Judiciary offers the following substitutes to Senate Bill 298, a bill to be entitled Act to amend Code Section 5-6-34 of the OCGA related to judgments and rulings deemed directly appealable and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 29th. Speak to the measure.
Thank you, Mr. Chair. This is another opportunity to make our court systems more efficient. What this bill does is in all judgments, orders, and rulings denying or refusing to grant immunity based upon sovereign municipal official, qualified, or any other immunity established by the United States Constitution or the Constitution of Georgia, what it allows for is that when the municipality comes before the court and asks for immunity, if immunity is denied, they have the opportunity to do an immediate direct appeal. Currently under the system, the case will be adjudicated and they would only be allowed to appeal at the end, which is a lot of time and a lot of money, especially based on the amount of discovery. What this would allow them to do is petition to the judge at the beginning for an appeal. They have 1 week to file that appeal, and once the judge denies the appeal or grants the appeal, they can no longer apply for another appeal in the process. So it makes the system work much more efficient. With that, Mr. President, I'll stand for any questions.
You have no questions, Senator.
Thank you, Mr. President. I yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. Secretary unlock the machine. On the passage of the bill, the yeas are 54, and the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed by substitution. Recognize Senator from the 38th for motion.
Mr. President, I ask for unanimous consent to lift Senate Bill 93 off the table.
Secretary, read the caption.
Senate Bill 93 by Senator Kemp of the 38th and others, a bill to be entitled Act to amend Code Section 20-2-153.1 of the Official Code of Georgia annotated, the Georgia Early Literacy Act, so as to prohibit the 3 queuing system from inclusion in high-quality instructional materials or structured literacy, to prohibit public schools from employing the 3 queuing system or visual memory as a basis for teaching word reading, to provide for criteria and for other purposes. That completes the order, Mr. President.
Is there objection? Without objection, Secretary, finish the caption.
Senate Bill 93 by Senator Kemp of the 38th and others, a bill to be entitled Act to amend Code Section 20-2-153.1 of the OCGA, the Georgia Early Literacy Act, so as to prohibit the 3 queuing system from inclusion in high-quality instructional materials and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Hickman, Chairman. Mr. President, Senate Committee on Education and Youth offers following substitutes to Senate Bill 93, a bill to be entitled Act to amend Code Section 20-2-153.1 of the OCGA, the Georgia Early Literacy Act, so as to prohibit the 3 queuing system from inclusion and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 38th.
Thank you, Mr. President. Colleagues, 70% of our fourth graders are struggling to read on grade level, and 69% of our eighth graders are struggling to read on grade level. The purpose of this bill is to strengthen the Georgia Early Literacy Act and the hard work of Senator Hickman and Representative Ballard to ensure that our students are not being taught using a flawed method. Hey, it's true. Oh, I'm sorry. Oh, the senator from the 4th. My apologies. To ensure that our students are not being taught using a flawed method of teaching reading known as 3Qing. Of course, we're going to keep learning and building on our successes. As an educator, I've known for a long time that something had to be done to improve literacy, not only in Georgia, but across the nation. And I'm determined to make Georgia the #1 state in the country for reading. That's why I came to the Senate, eager to work with the senator from the 4th, I got it right, and strengthen the Early Literacy Act. The bill defines 3Qing and ensures educators, new and old, are not given a flawed tool that teaches students to guess, not to read. Over a dozen states have taken this step, including my own home state of Ohio, which in many ways is ground zero for this technique. I've heard horror stories from parents who just want their child to know how to read. Many of these parents can trace their child's literacy crisis back to being taught students to read using 3Qing. When I bring legislation, I don't just want to bring words on a paper, but the voices of constituents. And former Georgia elementary teacher and mom, Missy Purcell, said this: "My son Matthew entered school as a bright, curious learner, eager to explore the world through books. But instead of receiving evidence-based reading instruction, he was taught using 3Qing, an approach that encouraged guessing rather than decoding. This method did not teach him to read, it taught him to guess, leaving him anxious, struggling, and believing he wasn't capable for his first 5 years of school. No child should experience that. As a former educator trained at the University of Georgia, I wish someone had told me and my colleagues that we were using ineffective and harmful tools. Decades of research confirm that skilled reading comes from decoding words, yet some universities across our state are still training future educators in debunked practices. 3Qing remains in our classroom despite Georgia's Early Literacy Act and the Dyslexia Bill. As Brene Brown said, clear is kind. Making it clear which tools are ineffective and even harmful does not limit teachers, it empowers them. Passing this bill ensures state colleges train future teachers in evidence-based practices. Kids like my son Matthew are counting on you. Colleagues, for parents, teachers, and kids like Matthew, I ask for your considerable consideration. And with that, Mr. President, I would love to see your board as I yield for questions.
You do have some questions, Senator. Recognize the senator from the 42nd.
Does the senator yield?
Yes, sir, I do.
I appreciate your bill. I have other questions for you. You're not the first senator to have your last name in this body, are you?
No, sir. In fact, I'm not. And the last senator to hold my last name now resides in the governor's mansion.
Do you further yield?
I do.
So comparing the work that you're doing here as a senator with your last name versus the work the previous senator with your last name did, who's doing a better job?
Senator, this bill has to go downstairs to the governor's office, so I'm going to defer to the current holder of that governor's mansion and say he did a wonderful job in this Senate.
That was a good answer. Congratulations. That's all I got.
Learning quick.
No more questions for you.
Learning quick. Recognize senator from the 56.
Thank you, Mr. President. Does the senator yield?
Yes, Mr. Chairman, I do.
Senator, I've read this bill. This has to do with reading. Is that accurate?
It does.
Do you further yield, Senator?
I do.
Have you ever read our Senate rules?
I have.
Senator, how do we address people in this chamber?
You know, Senator, I got so excited about working with the gentleman from the 4th that I just had to speak his name.
I understand. Senator, will you further yield?
I do.
Are you familiar with the Common Core methodology of teaching?
I am.
Is that what you used? when you grew up?
No, we did
All
not.
right, okay. Finally, we used to have a senator here, a great senator from the 53rd District, and he used to ask an important question to all incoming freshmen. Are you familiar with the words moral turpitude?
In fact, Senator, I am.
Please, if you would, Senator, yield and tell us all about moral turpitude.
Well, I would say that it would not be an act of moral turpitude for the gentleman from the 56 to support this senator's bill, even though I have spoken against quite a few bills from this well.
Well played, Senator. You're still my second favorite Kemp in the building.
Recognize Senator from the 19th.
Thank you, Mr. President. Senator, you yield?
Yes, I do.
I know this is Senate Bill 93. Is that the year you were born?
It's a little 5 years. No, it was not the year I was born. I'm sorry. It's not.
You've lived a clean
life. I was trying to
life.
do the math. Clearly, this is not a math bill. It's a reading bill. Maybe we need to
Well,
do a
Senator-
math bill next.
Well,
He's
Senator
a lot
Further
older
yield?
than he
years
looks.
prior than that.
Will Senator Further yield?
I do.
Did the previous Senator Kemp do a math bill?
You say, did he do a math bill? I'm not familiar that he did a math bill, but I do know that he started the Equian Association.
Gotcha. Well, that's very important to your bill, I can tell. Will Senator yield just a little bit further?
I yield.
A couple of questions. I noticed on page 39 you give additional powers to the majority party. Thank you for that. By allowing the Professional Standards Commission to adopt rules and establish criteria for the bill that you put. Can you tell me the names of the members of that Professional Standards Commission?
You know, I don't know the names of the members of the PSC, but I truly enjoyed working with Jody at the PSC to perfect this bill. They were great partners, and I really appreciate the work that they're doing and will continue to do to make sure students are taught and teachers are prepared to teach students to read in the right way.
Senator, you're extremely sharp. I want to ask you one last question, though, that I noticed you may have hidden in this bill. Probably something that if I would have thought of, I would have hidden in this bill. Will you yield for one more question?
I will yield.
I notice on line 15 you make it very, very clear that you want to set English language arts and reading standards. Are you suggesting that we adopt that as the official language?
Mr. Chairman, I'll let you be the judge of that.
Recognize Senator from the 32nd.
Thank you, Mr. President. Senator, would you yield?
Yes, ma'am, I do.
I'm looking at your bill, and you know we've had a lot of conversations about providing explicit material to young children. So I'm noticing on line 46 that you're preparing teachers to provide explicit approaches, and I just wondered if you could explain that.
Madam Chairman, I'm just trying to make sure that kids are able to read clearly and understand what they're reading, to know that I am not speaking about explicit material in that section.
You're not, sorry, would you further yield?
I further
You're
yield.
not speaking about explicit material, then why does it say explicit right there on line 46?
Because we want to make sure that teachers have clear-cut ways that are going to work to teach our kids how to read.
Thank you.
Thank you.
All right, Senator, this is the moment in time when you yield
All
the
right.
rail.
Colleagues, we have a lot of work to do as it relates to making sure our kids are prepared properly to read, and I ask for your favorable consideration for this bill. Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee, which is favorable to the passage of the bill? The chair hears none, and the report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage on the bill by substitute. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. Senator from the 34th, you're on deck. On the passage of the bill, the yeas are 50 and the nays are 3. This bill having received the requisite constitutional majority is therefore passed by substitute. Recognize the senator from the 34th for a motion.
Sorry.
Uh-oh, we got a new one. We got a new one coming to the well.
Thank you, Mr. President. I ask for unanimous consent for Senate Bill 236 removed from the table.
The senator has moved. Secretary, read the caption.
Senate Bill 236 by Senator Wicks of the 34th and others, a bill to be entitled an act to amend Code Section 20-2-150 of the Official Code of Georgia annotated related to eligibility for enrollment under the Equality Basic Education Act so as to provide that certain students whose parents or guardians are in active duty in the United States Armed Forces are eligible for enrollment in the public school of the intended zone in which they intend to reside regardless of whether they have entered into a lease, purchased a house, or otherwise secured housing within such intended zone to provide for related matters to appeal conflicting laws and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, Secretary, finish the caption.
Senate Bill 236 by Senator Wicks of the 34th and others, a bill to be entitled an act to amend Code Section 20-2-150 of OCGA related to eligibility for enrollment under the Equality Basic Education Act and for other purposes. Mr. President, the Senate Committee on Veterans, Military, and Homeland Security recommends that this bill do pass by substitute. Respectfully submitted, Senator Payne, Chairman. Mr. President, the Senate Committee on Veterans, Military, and Homeland Security offers following substitute to Senate Bill 236, a bill to be entitled an act to amend Code Section 20-2-150 of the OCGA relating to eligibility for enrollment under the Equality Basic Education Act and for other purposes. Mr. President, that completes the order.
I recognize our very quiet, very shy, retired Army veteran, the senator from the 34th. It is her first time to the well, ladies and gentlemen.
Thank you, Mr. President. And good evening, colleagues. I just want everybody to know that this is a veterans bill. And me being a 30-year Army veteran, this bill would allow parents of military children to enroll their children into public schools with the intent of residency with their military orders. With that, Mr. President, I yield the well.
No, that's not how it works, Senator. No. You'll be good to take a few questions here and there. We want to hear what that voice sounds like of yours because you're so quiet in here. But all right, let me recognize the senator from the 56.
Thank you, Mr. President. Does the good senator yield?
I do.
Senator, I just applaud your fantastic service for us in the military and bringing this bill. I notice it's really an education bill. Is there a reason why it went through the Veterans and Homeland Security Committee and not the Education Committee?
Yes, because the Mr. President assigned it to the Veterans Affairs Committee.
Good answer. So I noticed in this bill, Senator, if you'll further yield,
I do,
that you're allowing a student, if their parents aren't fully moved to that area, to go to the school of their choice. Is that correct?
Actually, no. What I'm saying is that me having dependents when I was stationed abroad, it just narrows it down to the duty station versus waiting on proof of residency.
Senator, you further yield?
I do. For one more question.
So I think it states in your bill on line 19, if you've not entered into a lease or purchased a residence, they'd have a school choice to pick that out. Are you a school choice supporter now, Senator? Don't wait, Senator, just answer.
Yes. No.
Welcome to the team, Senator. Welcome to the team.
With that, Mr. President, I yield the well.
Oh, come on. You can wait. You can do a couple more. It's going to be painless, I promise.
Okay.
All right. Recognize the senator from the 6.
Are you serious?
Thank you, Mr. President. Does the senator yield?
I do.
Senator, Can you explain to this body why you just voted against your fellow freshman, from the 38th bill, when you were coming up next?
Right. So so I explained to my freshman colleague, the Three Musketeers, why I was going to vote against this bill.
And
it's an internal conversation. Mr. Chairman, I apologize.
would you further yield?
I do, Mr. Chairman.
Would you say I'm on a need-to-know basis?
That is correct, Mr. Chairman.
Do you think the senator from the 38th should vote for your bill?
Yes, because this is a veterans bill, and with 14 million veterans out there that has sacrificed their life, and the children, because this is an educational bill, they want to make sure that upon receipt of their orders that they're allowed to register their children to the next duty station.
One last question, Senator, if you would yield.
Yes, Mr. Chairman.
Can you name all the veterans that serve in this body and what branches they serve in? Thank you.
Yes, Mr. Chairman. So I got the senator from the 33rd, 43rd, 33rd. He was in the Army, Air Force. Oh, so, hold on. Okay.
Let's go to an easier question. Let's go to
Yeah, I don't
easier
know.
question. Recognize senator from the 37th.
37, okay.
Thank you, Mr. President. To the senator from the 34th, do you yield?
I do.
I think you saw the display in your predecessor in the well. You know, the senator from the 38th was struggling to command this issue of district numbers for senators. And I think you, in your wisdom, probably have a command of that. Isn't it true that none of us get here alone? Those help get us where we are, and you're here with the help of others. Is that not true?
That is correct.
That being the case, I see the list of distinguished senators that are your co-sponsors on this bill. Could you recite for this body the Senate district numbers of your Senate co-sponsors on this bill, since they helped get you here?
I can. That would be the senator from the 54th, the senator from the 9th, the senator from the 8th, the senator from the 6th.
Isn't it great to come prepared?
That is correct.
Thank you very much.
Last one, Senator. This is going to be a friendly one. Recognize senator from the 38th.
Does my sister yield?
I do.
I'm very curious to know if you may have accidentally pressed the wrong color button in the last vote.
I did press the wrong button, and I owe you dinner.
Thank you.
Mr. President, with that, I ask for unanimous, favorable consideration, and I yield the well.
All right, Senator. All right, good job. Good job, Senator. All right. That was well worth it. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question? Be it ordered. Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. Senator from the 42nd, you're on deck. On the passage of the bill, the yeas are 54 and the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 42nd.
I ask unanimous consent that we lift Senate Bill 132 from the table.
Secretary, read the caption.
Senate Bill 132 by Senator Strickland of the 42nd and others, bill to entitle an act to amend Part 2, Article 6 of Chapter 7 Title 17 of the OCGA related to insanity and mental incapacity so as to require a hearing before a court orders an evaluation of the mental competency of an accused person to stand trial, to provide for the release of reports of such evaluations, to establish different procedures in cases where the subject has been accused only of one or more nonviolent misdemeanor offenses, including automatic dismissal in some cases, subject to exceptions, to provide for such different procedures and such exemptions, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws, and for other purposes. That completes the order, Mr. President.
Is there objection? Without objection, Secretary, finish the caption.
Senate Bill 132 by Senator Strickland of the 42nd and others, bill to entitle an act to amend Part 2, Article 6, Chapter 7 Title 17 of the OCGA related to insanity and mental incapacity and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland, Chairman. Mr. President, the Senate Committee on Judiciary offers the following substitutes to Senate Bill 132, bill to be entitled an act to amend Part 2, Article 6, Chapter 7, Title 17 of the OCGA related to insanity and mental incapacity and for other purposes. Mr. President, that completes the order.
Recognize the country lawyer from the 42nd.
Got my city lawyer shoes on today, though, Mr. President. Members of the Senate, I bring you Senate Bill 132. This bill comes as a recommendation from the Advisory Committee on Forensic Competency from the Georgia Behavioral Health Reform and Innovation Commission, the section that is chaired by Judge Gosselin up in Hall County. And what we're doing with this bill is addressing the competency process. This is where someone is charged with a crime. Either the individual themselves, their lawyer, the prosecutor, or the judge raises the issue of whether or not they're competent enough to face the charges that they have. The process that we have now has a big backlog. We're trying to process individuals to have the initial determination of competency, and then if you have to be restored to competency, the process takes even longer. So with this bill, we are doing two different things. On the front end, we're requiring a hearing initially to make sure that we have some due process built in and also some protection as a gatekeeping process when someone has the issue of competency raised. As initial hearing is whether or not to put you into that process. Second, when it comes to nonviolent misdemeanors, we're putting a shot clock, a shorter time clock on the process, the number of days that you have to be evaluated, and also the number of days you'll be restored. Because what we have currently is individuals that are sitting in our system longer than they would if they pled guilty for their charges, waiting for competency restoration. This bill comes not just with support from our Georgia Behavioral Health Reform and Innovation Commission, but also from DBHDD, NAMI, Georgia Council of Recovery, Georgia Mental Health Policy Partnership, all those that work on mental health issues here at the Capitol. I appreciate their support and their work on this bill. Happy to answer any questions.
You have no questions, Senator.
Ask for your vote on Senate Bill 132.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none, and the report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. Senator from the 16th, you're on deck. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize Senator from the 16th for a motion.
Mr. President, I would ask that you lift SB 121.
Secretary,
off the
read the
table.
caption.
Senate Bill 121 by Senator Harper and the 16th and others, a bill to be entitled an act to amend Code Section 33-7-11 of the official code of Georgia annotated related to uninsured motorist coverage under motor vehicle liability policies, such to increase the minimum uninsured motorist coverage required under motor vehicle liability policies for an individual convicted of driving under the influence or reckless driving, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Without objection, finish the caption.
Senate Bill 121 by Senator Harper and the 16th and others, a bill to be entitled act to amend Code Section 33-7-11 of the OCGA related to uninsured motorist coverage under motor vehicle liability policies, such as increase the minimum uninsured motorist coverage required under motor vehicle liability and for other purposes. Mr. President, Senate Committee on Insurance and Labor recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Walker, Chairman. Mr. President, Senate Committee on Insurance and Labor also allowing substitutes to Senate Bill 121, a bill to be entitled an act to amend Titles 33 and 40 of the OCGA relating to insurance in motor vehicles and traffic and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 16th.
Thank you, Mr. President. Appreciate it. This is SB 121 and has to do with insurance limits for people with DUIs. Currently, under Georgia law, we have not raised our limits for 14 years. This kind of gives you at least a look of what's going on. Current limits are $25,000 for any one person, $50,000 for any one accident, and $25,000 for property damage. Most of us drive cars that are more than $25,000 that are going on today. What this does is first offense for DUI would normally stay at the same limits. But what this bill does for a first-time offender, it would raise their limits to 50, 100, 50, so that would be there as an additional part. If they have a second DUI, they would then be required to raise that limit to 100, 300, 100. Most of the states around us are very similar except for Florida. Florida in 2007 raised the limits to 100, 300, 50 for first-time offense. They're required to keep the limits for 3 years. That's a requirement, and they're also required to carry proof that they do have insurance. That's part of the reinstatement of their license that's required. It's called an SR-22 that's required. And I think this is something we need to look at when someone is DUI. We need to have at least a little bit more limit on there because the fines they pay at the courts go to the courts. This raises the limit to protect the general public and to protect me and you if we have an incident with a driver who is DUI. That's it. Any questions, sir? No questions. Thank you for your consideration.
You do have one question. I'm sorry. Senator from the 53rd.
Thank you, Mr. President. Will the senator yield?
Yes, sir.
Senator, I know you've got great intentions with this legislation, but other than DUI, your legislation also includes reckless driving. Is that right?
No, sir. That was changed in committee. We were wanting that, but we did not get that. So we decided we'd go ahead and take the DUI so we could get that and get that done.
Okay, thank you for clearing that.
Okay.
Clarifying that.
Thank you, sir.
Recognize Senator from the 29th.
The Senator yield.
Yes, sir. I was looking for you.
Senator, could you expound on that just a little bit more as to why the reckless driving was taken out?
When we were in committee, that was one of the things that was felt like that because the reckless driving was a charge that was not necessarily DUI, that we would not move it, and other states had not used that combination of DUI and reckless driving, so we just stuck with the DUI level.
Thank you, Senator.
Yeah, no further questions, Senator.
Thank you, sir. Thank you for your favorable consideration.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the Board of Committee which is favorable to the passage of the bill? Chair hears none. The Board of Committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor will vote yea. All those opposed, nay. Secretary, unlock the machine. Senator from the 22nd, you're on deck. On the passage of the bill, the yeas are 53 and the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 22nd.
Thank you, Mr. President. I ask for unanimous consent to remove SB 204 off the table.
Secretary, read the caption.
Senate Bill 204 by Senator Jones of the 22nd and others, bills being titled Act to amend Code Section 17-7-70.1 of the OCGA relating to trial upon accusations in certain felony and misdemeanor cases and trial upon plea and guilty or nolo contendere, so as to allow for offenses that are not serious violent felonies, sexual felonies, or other certain offenses to be charged by accusation of the district attorney, to provide for definitions, to provide for conditions, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Out objection. Secretary, finish the caption.
Senate Bill 204 by Senator Jones of the 22nd and others, bill to be entitled an act to amend Code Section 17-7-70.1 of the OCGA related to trial upon accusations in certain felony and misdemeanor cases and trial upon plea a guilty or nolo contendere and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland, Chairman. That completes the order, Mr. President.
Recognize the minority leader. Present the bill.
Thank you, Mr. President. This is SB 204, basically an efficiency and transparency bill. Efficiency in two levels. Number one, it allows district attorneys to be able to charge non-serious felonies by accusation and also non-sexual felonies by accusation. This also would not apply, accusation process would not apply to a deputy that will be charged with a crime. So if a police officer actually was charged, that would still go through the grand jury process. What this allows is the district attorney to be able to basically charged by accusation certain non-serious violent felonies, non-sexual felonies. But it would not apply to if a deputy had a charge, that would still go through the grand jury process. Also efficiency from the standpoint that is, many of your deputies right now are going through this grand jury process on these non-serious violent felonies, and they're sitting for hours and hours, and what they really need to be doing is actually out there in the street actually protecting people, especially in your rural counties. They may be there all day, and what they really need to be doing is in the process of actually doing their job. Also, this allows victim cases to be moved faster into the queue, whether it's being charged by accusation or it's being charged by grand jury. I would make the note that actually 25 states right now make a grand jury optional. 23 states, including Florida and Texas, actually will be doing exactly what we're doing in this particular bill, to where non-serious violent felonies and non-sexual felonies could be charged by accusation. With that, Mr. President, I'll entertain any questions.
You do have one question, Senator. Recognize the senator from the 42nd.
Senator, you? Yes.
Mr. Leader, I just wanted to ask you, I think you hit on it at the end there, while this may seem like a big move in the law, isn't it true that this puts us more in line with the majority of states in our country as far as how we deal with the grand jury process versus accusations?
That's exactly right. As stated, actually 25 states make it optional to do a grand jury accusation, and then 23 other states, including such states as Florida and Texas, we would be following what they do, which says no grand jury for non-serious violent felonies and also no sexual felonies.
And one other question, if you will.
Yes.
Didn't we also hear in committee that with the grand jury process, we have a lot of officers that have to stay up after working shifts or aren't on the streets when they're having to wait for the grand jury process. And with your bill passing, those officers can be back on the street or back home with their families.
100%, they'll be able to go back home. You may have a deputy that's actually working a 7 p.m. to 7 a.m. He then or she has to go to court at 9 a.m. and yet also have to go back onto the road at 7 p.m. This allows them to basically get their sleep and actually take care of their family, to miss that kind of process where it's not really needed. Any other questions? With that, I yield the will, Mr. President.
No other questions, Senator. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Is there objection to agree into the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill. All those in favor will vote yea. All those opposed, nay. Secretary, unlock the machine. Senator from the 20th, you're on deck. On the passage of the bill, the yeas are 51, the nays are 4. This bill having received requisite constitutional majority is therefore passed. Recognize the senator from the 20th. Got to make the motion, Nature Boy.
Thank you, Mr. President. I ask respectfully that Senate Bill 284 be removed from the table.
Senators move. Secretary, read the caption.
Senate Bill 284 by Senator Walker, the 20th, and others, bill to be entitled and act to amend Chapter 5 of Title 10 of the OCGA, the Georgia Uniform Securities Act of 2008, so as to authorize the issuance of orders by the Commissioner of Securities directing persons who have violated certain securities provisions to return to investors, customers, or clients sums paid in connection with securities purchases and for other purposes. That completes the order, Mr. President.
Is there objection? Without objection. Secretary, finish the caption, please.
Senate Bill 284 by Senator Walker, the 20th, and others, bills to be entitled and act to amend Chapter 5 of Title 10 of the OCGA, the Georgia Uniform Securities Act of 2008, and for other purposes. Mr. President, the Senate Committee on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Walker, Chairman. That completes the order, Mr. President.
I recognize the Nature Boy from the 20th. There, Walker.
All right. Thank you, Mr. President. I know the hour's late, and y'all are in a hurry. I'm in a hurry. But when I was a young man, I used to go see Mr. Wrestling number 2 in the Macon Coliseum. He wasn't near as entertaining or as dynamic as the Nature Boy, Mr. Ric Flair. I do have a couple of Ric Flair quotes for you real quick. He was often would say, to be the man, you got to beat the man. And some of you all could learn from that. He was styling, profiling, limousine riding, jet flying, kiss stealing, wheeling and dealing, son of a gun, Mr. Ric Flair. Senate Bill 284 has to do with security fraud and provides a additional penalty that can be used to resolve these cases. So in the event that a person is found to have violated Chapter 5 of the Georgia Uniform Securities Act, under current law, the penalties can be a cease and desist order, denial, revocation, or conditioning of the license to operate in Georgia, and or civil penalties that would be remitted to the state of Georgia and go into the general fund. And the civil penalties can be a minimum of $5,000, I think, up to $50,000 for a single violation, with a maximum of $500,000 for more than one violation. That all goes to the general fund. There's no ability to restore the loss to the defrauded citizens of Georgia. So Senate bill in lines 26 through 32 add the ability to require the return of the invested funds to the defrauded investors. I think it's a good measure to protect Georgians, and I ask for your favorable consideration. Thank you, Mr. President. I yield the well.
The senator is yielded. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 54, the nays are 1. This bill, having received a requisite constitutional majority, is therefore passed. Recognize Senator from 56.
Thank you, Mr. President. I'd ask unanimous consent to move Senate Bill 129 from the table.
Secretary, read the caption.
Senate Bill 129 by Senator Albers of the 56 and others, a bill to be titled an act to amend Part 1 of Article 2, Chapter 5 of Title 48 of the OCGA relating to property tax exemption so as to increase the amount of a statewide home exemption for certain totally disabled veterans, to create new statewide home exemptions for certain partially disabled veterans and partially or totally disabled first responders, to provide for definitions, to provide for related matters, to provide for compliance with constitutional requirements, to provide for a short title, to provide for a referendum effective dates and automatic repeal, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? No objection. Secretary, finish the caption.
Senate Bill 129 by Senator Albers of the 56 and others, a bill to be entitled an act to amend Part 1 of Article 2, Chapter 5 of Title 48 of the OCGA relating to property tax exemptions and for other purposes. Mr. President, the Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler, Chairman. Mr. President, Senate Committee on Finance offers the following substitute to Senate Bill 129, a bill to be entitled an act to amend Part 1 of Article 2, Chapter 5 of Title 48 of the OCGA relating to property tax exemptions and for other purposes. Mr. President, a fiscal note to Senate Bill 129 has been attached. That completes the order, Mr. President.
Recognize Senator from the 56.
Good evening. We've worked very hard today. We've had a bit of fun, but I'm going to ask for your attention on a very serious matter. Senate Bill 121 is a way for each one of us to express our unwavering support for all of us who have served this in our community and overseas. The Georgia Supporting Those Who Sacrifice for Service Act. This legislation is not just a bill. It's an expression of the gratitude and respect we owe to the men and women who have risked their lives to protect our community and nation. Some of them serve and work in this very Capitol building. Specifically, this aims to augment the statewide homestead exemption for our totally disabled veterans and create new exemptions for our partially disabled veterans as well as our first responders. Our veterans and first responders have shown extraordinary courage and selflessness in their line of duty. They have faced danger, endured hardships, and made personal sacrifices that most cannot even comprehend. And when they return home from overseas
or from their shift, it's our duty to ensure they are not burdened by the financial hardships on top of the physical and emotional scars they may bear. This proposal increases the homestead exemption for our totally disabled veterans, as well as will ease the burden on those brave individuals who have given so much who are partially disabled. It also adds a new exemption for our first responders in the same vein. It is a small token to the immense gratitude of their service. By extending this, we recognize the sacrifices a broader group of individuals have made for us. They have defended our liberty and our freedom, both at home and abroad. This bill does more than just provide financial relief. It sends a clear message to our veterans and first responders that their sacrifices are not forgotten. It tells them that we as a state recognize their service and are committed to their well-being. It also sends a clear message to those who are currently serving and who seek to serve us in the future that we will have their back. This bill also provides for a referendum, allowing the citizens of Georgia the opportunity to express their support for our veterans and first responders. It's this type of a process that will ensure that it's a true reflection of the people. Let me be clear, this is not a handout. It is yet a way that the people of Georgia can give back to those given so much. It's a small gesture of thanks for the enormous sacrifices most will never comprehend. We must remember that they have paid a high price for their service. The Georgia Supporting Those Who Sacrifice for Service Act is a crucial step toward acknowledging and supporting our disabled veterans and first responders. It's a testament to our gratitude. Home properties have risen at an extraordinary rate over the last many years. And this is one way we'll be able to help have our veterans and first responders who've been disabled to buy that first home or be able to afford to stay in their current home. There are 21,000 first responders who are suffering some type of disability from an on-the-job accident, representing less than 0.2% of our state's population. Currently, there are 49,000 fully disabled veterans who have received a partial deduction on their homeowners' property taxes, which will go to fully. And there is a total of another 176,000 people eligible with a partial disability, representing 1.5% of our population. So as you can imagine, this is a small percentage of our population, but no one more deserving, and it will be impactful to them, to their family, in ways that we cannot measure. Senators, I'm going to urge each one of you to join me now in supporting this important piece of legislation. Let's stand together in backing this bill, affirming our commitment to our veterans and our first responders, and ensuring that Georgia remains a state that truly honors those who sacrifice for us, our heroes. With that, Mr. President, I'll yield for questions, or I will yield the well.
You do have one question. Recognize Senator from the 26th.
Senator, you.
I yield.
Senator, I understand what you're doing. Well, what does the future fiscal note look like for this?
I'm sorry, Senator, could you repeat
I
the
said,
question?
what does the future fiscal note looks like for this?
There is not a fiscal note because it does not impact state revenue. It impacts local revenue. As mentioned earlier, though, out of the 21,000 first responders that will qualify for this, that represents a little less than 2% of the Georgia population. And out of the current total disabled veterans, which number 49,000 have taken the exemption, there's a potential of 176,000 more that have a partial disability that could claim that, and that would be a percentage off of their homeowners' property taxes based on the percentage of disability. That represents approximately 1.5% of the population.
Senator, we can talk about population, but when you're dealing with taxes in your county or your city, it has an impact. So were you able to get an approximate how much money it would cost?
Senator, based on not knowing where every veteran and first responder resides today, we weren't able to get an exact amount. However, knowing the percentage is so small, I believe it is insignificant, and also knowing what great community leaders and neighbors our first responders and our veterans are, we believe they'll be giving that back at least tenfold.
You do have another question. Recognize Senator from the, okay, she's turned off. You wave, Senator from 36. All right, she waves. You have no more questions, Senator.
Thank you, Mr. President. Ladies and gentlemen, we did a lot of great things today. I think this would be a great way to finish our evening by supporting those who sacrifice us. Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 56, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the pro tem for a motion.
Thank you, Mr. President. I move to excuse the senator from the 48th for consideration of voting on the next bill on the calendar, please.
Without objection, the senator from the 48th is excused. Recognize the senator from the 21st for a motion.
Move Senate Bill 244 from the table.
Secretary, read the caption.
Senate Bill 224 by Senator Beach of the 21st and others, bills being titled and act to amend Article 1 of Chapter 11 of Title 17 of the Official Code of Georgia annotated relating to general provisions regarding the assessment and payment of costs of criminal proceedings so as to provide for the award of reasonable attorney's fees and costs in a criminal case to the defendant upon such defendant making a successful motion to disqualify the prosecuting attorney from his conduct in connection with the case, to provide for procedures for assessing and paying such fees and costs, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Without objection, finishes the caption.
Senate Bill 244 by Senator Beach of the 21st and others, bills being titled and act to amend Article 1 of Chapter 11 of Title 17 of the Official Code of Georgia annotated relating to general provisions regarding the assessment and payment of costs of criminal proceedings and for other purposes. Mr. President, the Senate Committee on the Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland, Chairman. That completes. Mr. President, Senator Beach of the 21st offers the following amendment: number 1, to amend Senate Bill 244 by deleting lines 23 through 26, by replacing D on line 27 with C, by replacing E on line 33 with D. Mr. President, that completes the order.
Recognize the senator from the 21st.
Thank you, Mr. President. Senators, I bring before you Senate Bill 244. Basically, what this bill does is if a prosecuting attorney is in a felony or misdemeanor case is disqualified for misconduct and the overall case is dismissed by the court system, Superior Court, Court of Appeals, or Supreme Court, then those individuals that were indicted are entitled to an award of reasonable attorney fees and costs incurred in defending themselves in the case. The judge in that case will consider the request of reasonable attorney fees and costs, and the fees will be paid by the county in which the criminal case was brought. That's all this bill does. I'll yield for questions, Mr. President, and or I will yield the well.
There are no questions, Senator.
Okay, the senator from the 22nd will speak to the amendment. It's a friendly amendment, which I agree to, and he will speak to the amendment, the minority leader. Thank you.
Recognize the senator from the 22nd. Speak to the amendment.
So I speak to the amendment, also the bill, Mr. President. So on the bill, as was stated, I know a lot of people may think they understand the genesis of this, but I want you to also think about this particular situation. Where if you had a young man or woman who was charged with a crime, had to hire a lawyer for $15,000, $20,000. The prosecutor was basically removed for improper conduct. Case gets dismissed. What kind of resolution does that person have? They have nothing. They're out that $15,000 or $20,000. What this case says is, that what this bill says, is if that situation happens, if you have that young person, possession of marijuana or whatever it may be, and the prosecutor's done something wrong, and that case is dismissed because the prosecutor did something wrong, they're entitled to have their attorney's fees back. And that's actually something that we probably would have pushed many years ago. The amendment basically takes out line 23 through 27 because that amendment, that line says that if you still go to trial, no matter whether you're found guilty or not guilty, as long as you go to trial, if the prosecutor was dismissed, you still get your attorney's fees. Here's the problem with that. A person may go to trial, the prosecutor may have been dismissed, whatever was wrong with the case got cured, they go to trial, the person is found guilty, they're guilty of murder, they're guilty of a crime, they then could still then possibly get attorney's fees. So they're sitting in jail getting a government check because the prosecutor was dismissed, but at the same time, whatever that dismissal was based on, that got cured, the case went to trial, the person was found guilty. So we eliminated that part because the intent was if the case was dismissed because of the prosecutor's wrongdoing, a person should be able to receive compensation for that. Well, I'll open it up for any questions if I have any, Judge. With that, I yield the well.
Sorry, Senator, but you have no questions. So. Does any other senator wish to speak for or against the bill? Chair hears none. Is there objection to order in the previous question? Chair hears none. The previous question is ordered. Questions on adoption on the amendment number 1. Adoption of amendment number 1, authored by the senator from the 21st. Is there objection? Without objection, amendment number 1 is added. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill as amended? All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 55, the nays are 0. This bill, having received a requisite constitutional majority, is therefore passed as amended. Recognize Senator from the 33rd for a motion.
Thank you, Mr. President. I ask for unanimous consent to remove Senate Bill 147 from the table.
Secretary, read the caption.
Senate Bill 147 by Senator Wright of the 33rd and others, the bill to be entitled an act to amend Article 3, Chapter 5 of Title 42 of the Official Code of Georgia annotated related to conditions of detention generally relative to correctional institutions of state and county so as to provide consent for the release of certain criminal history, vocational, and educational information for inmates upon release, to provide for issuance of an identification card and a program and treatment completion certificate, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Objection. Secretary, finish the caption.
Senate Bill 147 by Senator Wright of the 33rd and others, the bill to be entitled an act to amend Article 3, Chapter 5 of Title 42 of the Official Code of Georgia annotated related to conditions of detention generally relative to correctional institutions and for other purposes. Mr. President, Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers, Chairman. Mr. President, Senator Hatchett of the 50th offers the following amendment number 1 to amend Senate Bill 147 by striking may on lines 15 and 34 and replacing it with shall upon request from an eligible person. Mr. President, that completes the order.
Recognize the Senator from the 33rd. Speak to the measure.
Thank you, Mr. President, my fellow senators, colleagues, friends, and y'all. Today, I have legislation that asks the Georgia Department of Correction to provide inmates upon release with relevant documentation to assist the inmates in their post-release employment. The bill asks for certain documentation to be provided to the inmates to assist them with obtaining post-release employment. The documentation includes, but is not limited to, notification to the inmate if he or she is eligible to apply for an occupational license or certificate, a copy of the inmate's work record, a certified copy of the inmate's birth certificate and social security card, a copy of vocational training, a resume, including any trade learned by the inmate, documentation that the inmate completed a practice job interview. The bill asks that the Department of Correction coordinate with the Department of Driver Services to provide the inmates with a state-issued identification card or a valid driver's license card if needed. There is a friendly amendment from the senator from the 50th that I have no problem with, and I want to thank him for his help. And Mr. President, if there's no questions, I yield.
You have no questions.
Thank
Senator.
you.
Senator from 50, you wish to speak to your amendment? The floor is yours.
Thank you, Mr. President. I'll be very brief. This amendment is born out of a discussion with the Department of Corrections, the author, the chairman from the 56th. What it says is if a releasee requests these documentations, the Department of Corrections shall provide them. However, they have to be an eligible person. Those who have committed one of the 7 deadlies are not eligible for this program, so this clarifies that, and I just ask for your favorable consideration. Thank you, Mr. President. I yield the will.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the amendment number 1. Is there objection? Without objection, amendment number 1 is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill as amended. All those in favor of the bill vote yea. All opposed nay. Secretary will unlock machine. On the passage of the bill, the yeas are 55 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed as amended. Senate will stand at ease. We'll stand at ease for about 5 minutes.